This is Michael Popok for the new Legal AF YouTube channel. Yep, here's a chance to build from the ground up a new channel. Go out and hit the free subscribe, that oval button right now, and help us build another pro-democracy channel. We're doing it in collaboration with the Midas Touch Network. We're sitting at that intersection of law and politics and bringing you legal commentary and analysis like no other on YouTube that I'll be curating. All right, let's move forward. We got some new developments in Georgia. Get your hand cupped under your chin. It's about to hit the table. A Georgia Superior Court judge, and not just any Superior Court judge, but the one that had been involved intimately with the prosecution of Donald Trump, has just decided to rebuke completely his Georgia Supreme Court, who ruled against him 6-1 and find that there is a right to a woman in Georgia, finally, to have bodily autonomy. He has struck down the 6-week fetal heartbeat ban passed in 2019, celebrated by MAGA in Georgia, including Governor Kemp, to reduce women in Georgia to second-class citizenship and to put them on the doorstep of death and dying as a result of not getting their own reproductive health care of choice happening. ProPublica has reported it, and Judge McBurney has had enough. In a 28-page detailed opinion, he not only, on one hand, told his bosses to go, what's the word I'm looking for, legal AF themselves at the Georgia Supreme Court level, who sent him back the case after reversing him once before and said, okay, you're sending it back to me. You said my original grounds to find that the 6-week ban was illegal and unconstitutional, and I'm going to use a big legal AF term, void ab initio, meaning it was dead on arrival. It never could have been a law because it violated the then United States Supreme Court teaching and privilege established in the Roe versus Wade decision. Okay, give it back to me. I got a better way to do this. And that's what happened. The Georgia Supreme Court back in 2023 reversed Judge McBurney 6-1 and said, you did it wrong, McBurney. You can't rule that because the statute was passed in 2019 while Roe versus Wade had been on the books for over 50 years, enshrining in the Constitution of the United States a woman's right to choose. You can't say, well, because they changed it later on, this was dead on arrival in 2019, go back to the drawing board. You got to apply the Constitution the way the judges on the justices of the United States Supreme Court did it. McBurney said, well, send it back to me. And they did. And now, after having a hearing, an evidentiary hearing argument and briefing, he said that the act is unconstitutional under Georgia's right to privacy and liberty. And to be clear, for those that don't follow it as closely as we do on Legal AF, every state has a state constitution. The laws in that state constitution, the rights in that state constitution, in all 50 states, is not consistent. It just can't be violative of any federal constitutional right that's enshrined in the Constitution, a right of privacy or anything else. It can't give less than the federal Constitution. It can give more. Many states have different protected classes, different laws that aren't in the United States Constitution. The Florida Constitution looks like a statute book, looks like a code book, goes on forever. Others are a little bit more elegant in establishing their right to privacy, the right to liberty, the right to equal protection. Georgia does not, and most states don't, have express language in their constitution that governs reproductive rights and abortion. Neither does the U.S. Constitution. It's just the first time in the Dobbs decision that a right was given to a class of people, a group of people. Women make up the majority of this country. Everybody watching this podcast has a mother or had a mother, obviously. They gave birth to everyone and every judge. 100% of the judges came from a mother. That's a statistic you don't ever focus on, all right? So that right and the taking away of that right 2 years ago in the Dobbs decision by Sam Alito and his band of 6 MAGA on this U.S. Supreme Court was the first time in our entire republic that a constitutional right provided to a class of people, a group of people, was ripped away by a subsequent Supreme Court, never before. And so McBurney said, well, let me go looking around in the Georgia privacy laws and in Georgia constitutional provisions to see if I can find a right to privacy for a woman to make her own reproductive choices. And he found it. That's why I keep saying abortion, reproductive rights, restoring a woman to first-class citizenship in this country is on the ballot in November. Georgia is on the ballot in November, which is why this may be effectively the October surprise, at least in Georgia, and in that race of Kamala Harris versus Donald Trump we were expecting. All MAGA was celebrating the 6-week ban. It's gone. It's gone as of today, subject to whatever the Georgia Supreme Court does in the future to try to peel the 22-week ban, which is what's legal, according to McBurney, back to 6 weeks. Let me just read you one passage from this 28-page brief, and it's going to get a lot of press. It's the Handmaid's Tale, which we've talked about in that vocabulary a lot right here on Legal AF. I'm starting to get a little suspicious that maybe McBurney is a fan of Legal AF. We're certainly a fan of Robert McBurney, who presided over Donald Trump's special purpose grand jury that led to his indictment. We like McBurney for various reasons, but here's what McBurney said. Here's what McBurney said in his analysis on Handmaid's Tale. He said effectively that we cannot live in a society where, as in the Handmaid's Tale, commanders make the decision about a woman's right to choose. She has a fundamental right to make her own healthcare choices, he went on to say. On page 14 of the order that just came out, we just got a copy of it right here. He said, for these women, he means, in Georgia, the liberty of privacy means that they alone should choose whether they serve as human incubators for the 5 months leading up to viability. It is not for a legislator, a judge, or a commander from the Handmaid's Tale to tell these women what to do with their bodies during this period when the fetus cannot survive outside the womb any more than society could or should force them to serve as a human tissue bank or to give up a kidney for the benefit of the other. Considering the compelling record evidence about the physical, mental, and emotional impact of unwanted pregnancies on the women who are forced by law to carry them to term, like all the women waiting around the last 2 years for this decision in Georgia that had to give birth, the court finds that until the pregnancy is viable, a woman's right to make decisions about her body and her health remains private and protected by the Georgia liberty and privacy right, which McBurney rightly found is more extensive than what even the U.S. Constitution had provided. And he basically told his bosses that reversed him 6-1 a year ago, you're wrong. You're wrong that courts aren't empowered with the right to interpret the Constitution, that the Constitution speaks for itself, that the Constitution is not interpreted. That's what they get paid to do. And you've got it wrong about a woman's right to choose and the fundamental liberty interest at stake. Liberty. Reproductive rights. A woman's right to choose and to be restored to first-class citizenship in this country is on the ballot in November. 22 states criminalize abortion past the 6 weeks. Some states have an absolute ban on abortion. And they will prosecute and jail women and people who help women and healthcare providers that help women in those states. Okay? And the other 28 states, let's call them for shorthand purposes, the blue states, a woman has a right to choose. So tell me, and you can do it in a comment here, tell me how a woman in this country is a first-class citizenship when she can't freely move from state to state and retain her bodily autonomy. I'm waiting. She can't. That's why we needed it as a constitutional right, a right enshrined in the Constitution. Unless Kamala Harris gets elected and is able to reshape the courts to be more progressive, to be more humane, and reverse the decision of the Dobbs decision. And why not? Everyone's like, well, the Dobbs decision just got made 2 years ago, 2022. So what? This Supreme Court doesn't respect precedent, the right wing of the court. They overturned things 5 years ago, 8 years ago, 10 years ago, 50 years ago. They don't care. Super precedent doesn't matter to them. Things that are confirmed over and over and over again that we rely upon. Rip it out. Rip out the Dobbs decision. And it's on the ballot. 10 states in this country have on the ballot a state constitutional reproductive right to choose for the state in their own, to amend their own constitution, state by state. If that doesn't bring women and people who support women, if that doesn't bring them to the polls and motivate them to vote down ballot, up and down the ballot blue, I don't know what will. You have one shot at this, and it happens to be on November 5th. You got to register to vote in order to do that. This is an October surprise, at least in Georgia. This could turn the tide in Georgia and get people to the polls in large numbers to vote in November. There's no other way to put it. And I admire the eloquence, the gravitas, the intellectual and constitutional analytical gifts on display by Judge McBurney. I'd love to see him on the United States Supreme Court in a Harris administration. I wouldn't want to waste him on the Georgia Supreme Court, where 6-1, they were trying to defend the 6-week ban because they liked the sound of the name of the law, the Infant Protection Act or whatever it was called. I got news for these pseudoscientists and OBGYNs. Okay? A being before the 6th week is not an infant, and neither before the 22nd week. I have an infant that's 3 months old. I should know. It's just barely not a newborn. That's what chaps my backside. It's that they use this Orwellian Handmaid's Tale terminology. They get these laws passed by right-wing MAGA legislators who are not in step with most Americans who believe in overwhelming numbers of a woman's right to choose. In order to have a right to choose, it's got to be protected in a constitution, preferably the federal constitution. One step at a time. One step at a time. McBurney stood up against the tide and his own bosses at the Georgia Supreme Court and did the right thing. And for that, he should be applauded. We'll cover it all. Free subscribe. You like this kind of content, this hard-hitting analysis and commentary at the intersection of law and politics? I'm curating this new channel in collaboration with the Midas Touch Network. We call it Legal AF MTN for a reason. We got together and did this together. Find out what 40 million people a month already know, that Legal AF is the home of law and politics analysis and commentary like no other. And help us get to 200,000 free subscribers before Halloween. And so until my next Legal AF and my next Legal AF podcast or exclusive content right here on this new Legal AF MTN channel. This is Michael Popok, and I'm reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.